Welcome to Aging Insight with your host, John Ross and Lisa Schollmeyer. This program is made possible by
Welcome everyone to Aging Insight. I'm Lisa Schollmeyer. I'm here with John Ross. And John and I like to joke around and say this is the #1 program in the area for getting information about retirement, health, financial issues. And John, I think we're #1. We might be the only game in town.
Well, that's right, but that still makes us the best.
That's right.
And there's really no question about it that you need the information that we've got. And so whether it's here on Aging Insight Television, whether it's our Saturday live radio show of Aging Insight or our magazine Aging Insight, we're out here trying to get you the information you need for a successful, happy, independent senior years.
That's right.
Golden years.
Golden years.
Whatever you want to call it. That's what we want for you. So, when it comes to doing all of that, as you get older, medical care gonna be an issue.
That's right. The reality is, as we get older, we use more medical services. Our bodies betray us. They don't work exactly like they used to, and so we are dealing with a lot more medical professionals. And sometimes when we ourselves are in a state of illness or crisis.
Yeah, and the thing is that although you may have aches and pains in your knees or your back or things like that, you'll be the one communicating those to your doctors and going back and forth with your doctors as far as how all of that's going to work. The question is, what happens if you're incapacitated? What happens if mentally you're unable to be able to make your medical decisions? In that case, who's going to do it?
Right. And so today we're going to talk about what the law says about who can make your medical decisions if only in the event that you cannot. And John, I want to start there because so long as you are competent, you're able to take in information from your medical providers, you are able to communicate with them about what your wishes are, you make your medical decisions.
That's right. You can even make medical decisions that refuse life-saving care.
That your kids don't like or your spouse doesn't like.
I'll often make the joke when I give speeches. I'll say, imagine I've appointed Lisa over here as my agent under the power of attorney, and I'm at the hospital, and the doctor comes in and he says, "John, I got bad news. I got good news. The bad news is you're going to die. But the good news is we have this magic pill, and if you take this magic pill, you'll live." And I look the doctor straight in the eye and I say, "Hey, you know what? Not interested. I don't want the pill. But Lisa, there you are. You don't want me to die. So you're looking over at the doc saying, hey."
Yeah. Put it in a piece of cheese and shove it down
his
his throat.
It's like a Labrador, right? Right. Yeah, shove it in there. It's not how it works. I always get to make my own medical decisions as long as I'm competent.
Right. So what we're about to talk about is beyond that point if you are not competent. So as long as you're competent and able, none of what we're about to talk about applies. But the reality is, for many of us, there might be a temporary period of incapacity, such as a stroke or a fall that leaves you unconscious.
Yeah, you just got knocked out.
Yeah, or it could be more permanent type of incapacity, such as dealing with dementia or an issue like that. So
yeah, so the first thing is we've got several different laws when it comes to making medical decisions, and you might just think, oh well, a medical decision's a medical decision, so wouldn't this all be the same? Nope, it's not. It's all related to the stage of medical care that you're receiving, because you might have emergency medical care, you might have your ordinary day-to-day medical care, and then you might have life-ending medical care or absence thereof.
Right.
And so you're going to have different scenarios with different situations. So let's go ahead and knock out the emergency one, because that's pretty easy. If it's an emergency, nobody's got to consent to nothing.
That's right. So if it's an emergency, the medical provider on hand can essentially make decisions that now all of those decisions must be in the direction of preserving your life.
That's right.
So the EMTs on the scene, the doctor in the ER, those decisions can be made without your consent in order to prolong and preserve your life.
And they don't really have any obligation to investigate further beyond just treating that emergency situation right then. Now, this is related to life-threatening situations, right? If you show up at the ER because you've got a splinter, well, you might be at the ER, but that's no emergency. And so
you might have a heart attack when the bill comes in, but
yeah, but that's not an emergency. So when we're talking about emergencies, we're talking about things that if not treated right then are likely to kill the patient. And in those cases, they really can do basically whatever they want in order to save the patient. Their job to save you, to keep you alive. And so if they don't know anything else, for example, maybe you have a religious issue with a certain type of medical procedure.
like a blood transfusion.
Like blood transfusion. Well, if they don't know that, they're under no obligation to not do a blood transfusion if they medically think that a blood transfusion is what you're going to need. So their job to do all of that. So in an emergency context, pretty much whatever.
Yeah, medical people will make the decisions, whatever it takes to preserve your life.
That's right. In the regular medical situation, now we get into a whole different deal. Again, first of all, if you can make your own medical decisions, you always get to make them. You can't voluntarily assign your medical decision making to somebody else.
That's right.
I can't just say, you know what, no, don't ask me, ask Lisa.
Yeah. Now, in reality, you may consult closely with family members or trusted persons, but ultimately the medical decisions are your responsibility so long as you can make them.
That's right. But if you can't make those medical decisions, then we have a set of laws called the Medical Decisions Act, and it's got a slightly different name on the Arkansas side, but it's all basically the same. And it's going to give a list of priorities of who is going to make those medical decisions.
That's right. So, well, John, why don't we take our first break, and then we'll come back and we'll start going through the list and in what order people could be asked to make medical decisions for you. So we'll be right back.
Lone Star Truck Group is now hiring service technicians. We also have career opportunities in every department. With 23 locations across the South, work where you want. The best product lines in state-of-the-art facilities. Work with the best employees, receiving great benefits, competitive wages, and a safe, clean work environment. Receive ongoing product training for continuous career development. Contact Lone Star Truck Group today and recruit it at LoneStarTruckGroup.com.
Welcome back to Aging Insight, everybody. I'm John, that's Lisa, and today we're talking about who is going to be making your medical decisions if you're incapacitated. Yeah, if you're incapacitated, it's not you.
Right.
And if it's not you, then who?
Yes, it's got to be somebody.
Well, the law is going to step in here and give us a list of priorities, and number one on that list is?
Number one on the list to make your medical decisions, if you cannot, is a court-appointed guardian. Now, John, we have talked on prior shows about guardianship.
Yes.
And just to refresh our listeners and viewers, having a court-appointed guardian is quite a lengthy process. So when a guardian is appointed for you, that means someone has filed papers at the courthouse. Someone has likely gone through some sort of background check. They have appeared before a judge. They have submitted medical evidence to that court that you are incapacitated and need someone to make medical decisions for you. You, as the incapacitated person, have been served with the guardianship papers, whether you realize it or not. The court may have even appointed another attorney to come and review your medical charts and talk with you to see if you truly are incapacitated. But at the end of the day, a guardian is someone who's appointed only after a fairly lengthy process with the courts. And John, this process can be shortened somewhat in perhaps an emergency or a temporary type situation, but there is still a lot of paperwork and a lot of interaction with the court that is going on to get to a point that you have a court-appointed guardian. But once that guardian is appointed to make medical decisions for you, then they are the designated decision maker by law.
Yep, they're number one. They trump everybody else. They trump the spouse. They trump the kids. They trump everybody else on the list. So yeah, guardian, big deal there.
Yes.
Number two on the list. So if you don't have a guardian, and most people don't have a guardian. So the number two person on the list of who's going to make your medical decisions is the person you have chosen in a validly executed medical power of attorney. Now, we've talked about powers of attorney on the show lots and lots and lots of times. I bet we don't get 2 shows without at least mentioning a power of attorney somewhere along the way. That's because they're so important. The reason most people don't have guardians is because it's expensive, time-consuming, public, embarrassing. It's awful. If you can avoid it, avoid it. And the easiest way to avoid it is by making sure you have powers of attorney, which include a medical power of attorney. This is the document that says, here's who I want to make my medical decisions. This is you choosing. A guardianship is a judge choosing who's going to do it. But with medical power of attorney, you're getting to pick. So while you're still alive, while you're still competent, you still got your brain, you sign that medical power of attorney and you say, I want this person to make my medical decisions. And probably if that person can't do it, then I want this person to do it. And you can even have as many alternates on there as you want. But the medical power of attorney, once again, is going to trump everybody else except for the guardian.
The guardian, right. And I like to think of doing a medical power of attorney as if you are drafting your team players. Okay, you sign that medical power of attorney and you have drafted for your team of support agents who, if you cannot make a medical decision, that you are authorizing them to step up and make a medical decision.
It's like the fantasy power of attorney, like there's fantasy football.
Right, yes.
You're creating your fantasy team.
Fantasy, that's right. And the reason I point that out is because you pick who you think is best for you. There is no requirement, there's no magic. If your closest family member is not the right person to be your medical power of attorney, then don't put them down. If your best friend since 4th grade is the person, then put them down. There is no right or wrong answer as to who you select as your medical power of attorney, other than who you want.
That's right. So, guardian, number 1. Your chosen person, number 2. Mm-hmm. After that, it's a spouse. Now, notice I said spouse.
Yes, it is the patient's spouse.
Spouse. It's not the spouse that's been married to them for a certain length of time.
Right. And
I've had several situations where some very upset children are calling the office. Their father's had a medical accident. He's recently married, maybe even as recently as a week. And that new spouse is saying, kids get out of here, I'm in total control. Well, guess what? If he didn't have a guardian and he didn't have a medical power of attorney, then the next in line is the spouse.
Right, and it's the current spouse. There is no time length of how long that marriage has been in place. It is the spouse. And John, just to add to that, it is the legal spouse. So in our community, we do occasionally have couples show up at the ER or the hospital, and there's the patient, and then there's the person who says they are the spouse. But yet we find out from the kids usually that there was never a marriage, that they're claiming essentially common law spouse. So when we are referring to a spouse for medical decision-making purposes, we are referring to someone where there was a marriage license that is on file with the clerk's office, or there is a judgment finding of common law marriage that is also on file with the clerk's office.
Yeah, I think a lot of people just don't get the whole common law deal here.
Which of course you can't be common law married in Arkansas, period.
Right, there is no common law in Arkansas. But even in Texas, if you are going to have a common law marriage, people have heard, oh, well, if you share the same name, you live together, you have the same bank account, all of that makes you common law. No, that is evidence that a court could use to enter a judgment that even though you didn't really get married, you're still treated as being married. But you are not the common law spouse unless you have a court order that says so. And I bet we get calls from the hospitals, the home healths, the hospices.
Every week
with somebody showing up, and they're calling us saying, well, we've got this person in here and they're saying they're the common law spouse.
Yeah.
Well, do they have a court order? No.
No, but they showed me their driver's license and their checkbook and the tax return. Doesn't matter. And John, the funny thing is that usually comes up when the couple, I don't ask someone, are you really, really married when I first meet them?
Right.
But often, if a senior is having medical issues and a couple is presenting to the medical provider as husband and wife, everyone is typically treated that way. Often, it's the adult children who come in and say, oh no, this is not a spouse. This is, dad's girlfriend. and then it gets a little dicey. So, if you don't have a guardian, if you haven't signed a medical power of attorney, then the legal spouse that has a piece of paper of some kind, either a marriage license or a court order, is the next decision maker on the list.
That's right. And now we're gonna step down one more, and we get to one of my favorites.
Yes, the next in line is any one of the available adult children of the patient.
Yes, your reasonably available adult children. What in the world does that mean?
Right.
And I'm that's a legitimate question. What does that mean? Because I don't know.
Yeah, reasonably available. These days we all have smartphones, telephones, email, FaceTime. Almost anyone anywhere in the world can be reasonably available.
Yeah, so does reasonably available mean they're standing right there? Or does reasonably available mean, you would have to call them? What if you've got a brother and a sister there, and the brother says, hey sis, why don't you run down to the commissary and get us a couple of drinks, and then he runs in and makes all of the medical decisions.
Right. So, the law doesn't say it has to be a majority of the adult children. It just says any one reasonably available adult child can make decisions for a parent if there's no guardian, if there's no medical power of attorney, and if there's no spouse.
Yep, and there's no tiebreaker in any of that either. No. So, just a catastrophe waiting to happen on all of that. All right, we're going to take one more break. We're going to get to some of the more remote ones down there and what that all could mean to you as well. So stick around. We'll be right back.
Lone Star Truck Group is now hiring service technicians. We also have career opportunities in every department. With 23 locations across the South, work where you want. The best product lines in state-of-the-art facilities. Work with the best employees, receiving great benefits, competitive wages, and a safe, clean work environment. Receive ongoing product training for continuous career development. Contact Lone Star Truck Group today and recruiting at LoneStarTruckGroup.com.
Welcome back, everyone, to Aging Insight. I'm Lisa Scholmeyer here with John Ross, and today we're talking about who would make your medical decisions on your behalf if you were incapable because either you were unconscious or your brain is so scrambled up at the moment that you cannot make your own medical decisions. So we have talked about that a guardian could make those decisions that is court appointed. But that's quite a process. Also, an agent that you have listed on a validly executed medical power of attorney could speak for you and make your medical decisions. If you're married, then a spouse could make your medical decision. And we ended our last segment talking about how just one of your adult children who is available could make all of your medical decisions on your behalf. But John, what happens, we have a lot of folks who don't have any of those resources.
Right, so as you continue down that list, you're going to get a little further and further down. The next one down beyond your children is going to be your reasonably available nearest kin.
Right. And
once again, I don't know what that means, and I don't know what nearest kin means in the context of, I think about it in the reality. Let's just say that I walked into the hospital right now. Walked in, wandered around through the hospital until I found an unconscious person. Stood around looking at them until some medical person walked in. And when they walked in, I say, "Oh yeah, I'm their nephew."
Right.
I'm the reasonably available nearest kin. I would like to make decisions for this person. How in the world is that? Does anybody know that?
Right, nobody knows that. And then, and then we have folks who have very close relationships with maybe a sister-in-law that, the brother who was the relational connection has died.
Right.
But, over the years, these two ladies were best buddies. Is that sister-in-law akin under the law at this point?
Well, yeah, probably not.
Yeah.
Not in the way the law would use
Yeah.
that term, but yeah, I've had a lot of situations where they have a close relationship with that in-law in some way, shape, or form, but that's not on the list. So we've got actual relatives of distance, but we occasionally, Lisa, will run into what I've often referred to as the senior orphan.
Right, the senior orphan who either through we've had some that have had families, but everyone has died and they have no one else. We've had some that just kind of went through life a little solo and they don't really have anyone. So there's no one that fits into any of these categories for this particular senior.
Yeah, and so they've got no guardian, they got no medical power of attorney, they got no spouse, they got no kids. Frankly, they got no, at least reasonably available kin of any form.
Right.
We get down to the very bottom. Well, in that case, the hospital themselves, or the treating physician, along with another treating physician, or another physician,
yes.
The two of them can now make your medical decisions.
Right. So basically, the medical providers themselves can make those decisions. And John, a lot of times this is because hospitals have ethics committees that are instituted to assist with medical decision making, in this situation. But these might be doctors that you don't have a relationship with previously. But if you're unconscious, and we don't have any of these other resources, then they're the ones making the medical decisions.
Yeah, and understand that doctors often have a very different view of medical care than you do. There was a study a while back where they asked a bunch of ordinary people whether or not they would want CPR if they started having a heart attack right now. And 75% of everybody they asked said, "Oh yeah, if I start having a heart attack, you get over here and do CPR." they asked the same question to every doctor in a particular hospital, and it was only like 3% or 5% of all those doctors said, oh yeah, do the CPR. All the rest of them said, no
Right.
CPR for me. So the doctors clearly have a different opinion about certain medical treatment than the going around regular public does. So keep in mind that if you have not lined this out properly and you don't have the people that are going to be able to make your decisions, it will be strangers.
That's right. So
Now, all of that's the regular medical decisions. You also have your end of life decisions. So you're brain dead, your body's only going to keep on living with life support, no hope of recovery.
right. So in that situation, when we're really at the more of the end of life medical decision making process, again, your wishes can, if you can express them, are to be honored. If you are unconscious and cannot express them, then we're going to be asking, is there a living will that you may have executed which has your wishes written down in writing for just this situation? And if you have a living will, then the terms of that living will, which is where you've said what kind of artificial life support you want or you don't want at that end of life point in time, those wishes are to be honored if you have that already signed and executed.
Yep. And if you don't, you're going to get a priority list that looks close to the same as the one we just covered. Guardian still always wins. Medical power of attorneys after that. Spouses after that. We now have a majority of the reasonably available adult children.
Right, for end of life.
For end of life.
Yes.
Nearest kin. And then at the very bottom, it's actually the doctor and a member of the clergy.
Yes.
So kind of an interesting little twist on it there for end of life decisions. So now you know, and hey, pick. You decide. Do your medical power of attorney. You pick who's
Yeah,
going to
do
make
a living
your,
will. You know,
yeah.
you make your wishes known while you can, and hope you never find yourself in that situation. But I always want you to be in the driver's seat, and that's really what Aging Insight's all about.
That's right. So that's why we bring you the show. That's why we bring you things like our Aging Insight magazine, which is out in your doctor's office, or you can always call our office at Ross and Schollmeyer and we'll get you a copy. And you can listen to our radio show every Saturday at noon on 107.1. Until next week, have a good one.
Bye-bye.